CR1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in Carter versus the Industrial Commission of Arizona as one respondent, and then Noranco Manufacturing, the respondent employer, and Liberty Mutual Insurance, the respondent carrier. Let's begin with introductions of counsel. Thank you. Thank you very much. Let me go through a few preliminaries. Each side has 20 minutes. If you would like to, as the appellant or petitioner, would like to reserve time for rebuttal, when you go to the lectern, if you'll let us know how much time you'd like to reserve, we will do our very best not to poach on it so that you'll end up with it at the end of the day then. We are recording the proceedings today, both audio and video, and you can actually see them on the video if you go to either YouTube in a few days, or you can go to our website and you can see what you've done. Because we're recording them both ways, when you go to the lectern, if you would please restate your name. That way, if someone is listening to the recording, they can identify the speaker. Let me advise counsel that we have reviewed the briefs in this matter carefully. We've actually met and discussed the case. We're familiar with the issues and your arguments, and we have read the pertinent portions of the record. So we are prepared to engage with you today. So with that said, let's go ahead and begin.
Good afternoon, and may it please the court. My name is Tom Wilmer. I'm appearing on behalf of the petitioner, Barbara Carter. With respect to reserving time for rebuttal, I usually just let it play out as it is, but 5 minutes would be sufficient. Petitioner comes here today to ask this court to reverse the decision of Judge Powell and remand the matter back to the Court of the Industrial Commission for hearings de novo. We ask that the court do so because we submit that Judge Powell utilized an inappropriate standard in addressing the question of whether or not the industrial injury brought about an aggravation which is compensable relative to a need for surgery. I respectfully assert that the court can glean from Judge Powell's award his mindset with respect to what is required in terms of aggravation. If you read Judge Powell's award, at the outset he states that applicant, petitioner, is at the position that she needs further treatment because her symptoms continue, which is accurate. That was our position. In the body of Judge Powell's award, he characterizes a conflict of the opinions between the doctors. In finding 3, he states the doctors disagreed as to whether applicant's work injury contributed to the progression, that's the word he used, progression of the pre-existing degenerative condition, and any current treatment that applicant may need for her current arthritic symptoms. With respect to Dr. Bradway, Judge Powell specifically outlines the basis of Dr. Bradway's opinion, which is that the incident in question did not cause any structural change in the knee. And I respectfully submit to you that the law in Arizona does not require a structural change. It goes all the way back to the Arizona Supreme Court's decision in Gulick, an opinion that was written by Justice Struckmeyer. And Justice Struckmeyer very simply states, accident benefits are not divisible into portions, but the whole thereof is included when there is a relation between the accidental injury and the treatment reasonably required. He goes on to state, with respect to the findings that were issued by the ICA, the findings of the board are without the prior. The findings of the board are that without the prior instability, a lumbosacral strain in and of itself would not have occasioned a spinal fusion, which is what the worker received in that case. Justice Struckmeyer goes on to state, accepting this as medically conclusive, it does not support a finding that the operation was occasioned by the existing instability alone. He goes on to state the commission presented no medical testimony at rehearing. Doctors Hartman and Hunter each testified at hearing that in their opinion, the lumbosacral strain was related to the necessity of relieving the petitioner's pain by surgery. And I submit to you that those are similar facts to what we have here. Ms. Carter, no doubt, has pre-existing arthritis in her knee. But as the record reflects, she was doing reasonably well before the industrial incident. She then has a twisting mechanism of injury, and from that point forward, she has unrelenting symptoms that completely disrupt her abilities to do things from a physical standpoint, plus she's in severe pain. Dr. Miller testified that based upon those circumstances, the event in question caused a symptomatic worsening, which brought about the need for surgery.
If I may, I'd like to ask you some questions about some of the points you just raised. But I want to start with having read the testimony of the doctors, where I think there were points of agreement. It seemed to me they both agreed that Ms. Carter had a pre-existing degenerative knee condition, arthritic knee, and they both agreed to that. Okay. And it appeared to me they both agreed that that condition had been aggravated, or rather putting it in the positive voice, or the active voice, the industrial injury had aggravated that knee condition. Okay. And under Arizona law, that aggravation is compensable. You've cited a couple cases, I think Mandix. Mandix, thank you, Mandix. Okay, so at this point we're all in agreement. Now this is where I see the divergence in what they had to say. So I would like to get your take on this, so to speak. As I read Dr. Miller's testimony, he believed that based on her symptoms and the other factors that you inserted into the hypothetical question, that she was her ongoing symptoms were causally related to the aggravation of her knee caused by the industrial injury, and that she needed further medical care, a knee replacement. That was his testimony. Dr. Bradway, as I read his testimony, concluded that her need for additional treatment was unrelated to the industrial injury, because he could not, in looking at the x-rays and the MRIs from 2006 and 2014, I might be off a year, but roughly, x-rays, other objective tests, that he could not attribute her ongoing problems to the industrial injury, but rather to the pre-existing condition. So in that sense, he didn't see any anatomical changes or structural changes that he could then say, yeah, I think that injury, the industrial injury, is causing some type of permanent impairment, or at least necessitating additional medical treatment. Isn't that your classic conflict in the medical evidence?
Sure, it's a conflict.
Yes. So the ALJ makes that determination, or makes the, let me put it in the terms of basketball, decides the jump ball in that case, and we normally defer to the ALJ's findings.
You do, unless his findings are legally insufficient.
So what's legally insufficient about Dr. Bradway's testimony?
Dr. Bradway adheres to the notion that you cannot have an aggravation of an industrial injury absent an anatomical change. In his testimony, he talks about a spur breaking off, or other types of objective injuries that you can look at an x-ray and say, aha, this is what happened. In essence, that's the new injury. That's not an aggravation, that's a new distinct injury.
Can you give me a citation to his testimony where I can find that?
Yeah, I cited it in my brief.
Okay.
It's on starts on page 14 and it goes on through page 16. Actually, I'm sorry, it goes on to page 17. I spent considerable time with Dr. Bradway trying to corner him on the question of, put aside objective change, let's talk about a symptomatic worsening that brings about the need for treatment, which is precisely the law under Mandix and under Gulick and under industrial indemnity and some other cases that I can cite to that are not quite on point, but they do recognize that notion. He wouldn't answer the question, and that's where it ends off in my citation. He will not go to the question of, did a symptomatic worsening occur here that brought about the need for treatment? He wouldn't do that.
Well, let me ask a more, perhaps a more basic question. He is looking at Ms. Carter, and he is evaluating her medical history. He's looking at x-rays and MRIs. He met with her. He examined her. He obtains her history, looks her, he is familiar with her, kind of everything about her when it comes to this knee. And based on all that information, he determines, and he does rely on the objective information that's not relating to her report of pain symptoms. And not that I'm in no way suggesting she was not believable. No way suggesting that. And he says, I just can't get there to find anything more than a temporary aggravation because I just don't see it in the records. I don't see it in the reports. I don't see it in the MRIs and the x-rays. What is wrong with that approach?
Right. There's a distinction between medical causation, the way a doctor thinks, and legal causation, the way that we think down here. Dr. Bradway's focus on a structural change does not carry the day. The law is clear. Mandix, II, industrial indemnity, Gulick, Arizona Supreme Court, you don't have to show a congenital change in the condition. If the incident brings about a worsening of a pre-existing condition, which brings about a need for treatment, or in the case of industrial indemnity, brings about an increased disability, that's a compensable consequence. And as I said, medical causation versus legal causation, some doctors, they think in doctor world. They don't think in lawyer world. I don't want to give the court anecdotal experiences, but that's the way it is. And I submit to you that is Dr. Bradway's mindset. And in my reply brief, I pointed out that's his thinking. He's thinking anatomical change. He's not thinking subjective worsening, bringing about the need for treatment.
But is one way to characterize your argument that that's the only way, what you just espoused, to look at that testimony? Can we look no other way? And because that's the only way, there was error here.
I don't know how you can see it any differently. I really don't. And you have to look at how Judge Powell characterized it. What was his mindset? His mindset is structural change. His mindset is progression of the condition. That's not the law. That's not Mandix. That's not Gulick. That's not industrial indemnity. And there's a couple other cases. One is McCrary, which is cited in my brief. And there's a case cited within McCrary, although those are occupational disease cases. But the underlying condition was allergies being worsened by work. And in both those decisions, the court held that the occupational disease statute does not apply, which has a different risk test to it. Therefore, those would be compensable conditions. I understand where you're coming from, but I submit to you that a reasonable theory of the evidence, a reasonable reading of the record in this case, can only lead to the conclusion that Dr. Bradway is thinking structural change.
But your argument requires you to prove even more than that, isn't it? It's not a reasonable, it's the only reasonable way to read the record is the way that you suggest.
Right. A reasonable theory of the evidence. I think
well, you're saying the only reasonable, and the reason why I'm pushing a little bit is if the ALJ could have viewed the evidence in one way or another, I don't think your argument succeeds.
Well, the problem with that is the court has to obviously look at the evidence, but you can't weigh it. And in this case, I don't know how you can get to any other conclusion than Dr. Bradway, placing his eggs in the basket of structural change. Yes, there's some evidence from Dr. Greenfield, but there's a factual dispute there. And Ms. Carter testified that, contrary to what Dr. Greenfield said, I was still having problems with my knee. There's also testimony from Dr. Miller saying that she had a cortisone injection, improvement would be expected, but that's not the end of it. And that conflict, to the extent there's a conflict, Judge Powell did not resolve it. And in addition, Judge Powell did not find Ms. Carter to be non-credible. He just didn't address that. So at the end of the day, I submit to you that there's really nothing to support the conclusion that there's a reasonable theory of the evidence by which the award can be sustained. So unless there's other questions, I'll keep as much as I can here for rebuttal. Thank you.
May it please the court, counsel. My name is Lisa Lamont. I'm here on behalf of the respondents, Noranco Manufacturing and Liberty Mutual Insurance. The issue, I believe, was correctly framed by you, Judge Norris. This is a pure conflict in the medical evidence, which the ALJ reasonably resolved. With all due respect to Mr. Wilmer, he's mischaracterizing Dr. Bradway's testimony, and he's also misstating the law. This case is nothing more than a conflict in the medical evidence that the judge resolved, despite his attempt to dress it up as something more. Now, I don't normally spend a lot of time in oral argument going over the facts of the case, but given that Dr. Bradway's opinions are at issue here, I think spending a little time addressing what exactly he found is important. Dr. Bradway evaluated the petitioner in an independent medical examination. He found a couple of things. He diagnosed arthritis in the left knee. As you indicated, everyone agrees that she has. In talking about the industrial event, he noted that this was a very minor event, similar to events documented by her primary care physician over the years leading up to the industrial injury, when she would have a flare-up of her arthritis, receive treatment including anti-inflammatory medications and viscosupplementation, and then it would go away. The industrial injury was very similar to that. He agreed that it was appropriate to treat this as an industrial injury and that it was appropriate for her to get the care that she did through Concentra, some physical therapy, the referral to Dr. Greenfield, the cortisone injection, which by Dr. Greenfield's records she responded well to. And despite the petitioner's assertion that the injection did not help her and that she's continued with unabated symptoms since the industrial event, Dr. Bradway noted that Dr. Greenfield's records, the treating physician, were contrary to that. She reported she had a substantial benefit from the injection when she went back on October 27th, that she had a completely normal examination at that time. Dr. Greenfield noted that she had no swelling, normal range of motion, no tenderness, absolutely zero findings with respect to her knee, and that's the reason why Dr. Greenfield discharged her at that point from the industrial injury without any impairment, without any work restrictions. Dr. Bradway agrees that that was appropriate. Now, in testimony, he expanded on his opinions because the real issue with respect to continuing benefits is whether the current recommendation for a knee replacement was related back to this industrial event or due solely to her pre-existing degenerative knee. Dr. Bradway ultimately concluded that the knee replacement was not an industrial responsibility for a number of reasons. One, again, that the industrial injury was a very minor event. Based on the objective data in Dr. Greenfield's report, this was a temporary aggravation which had completely resolved by then based on the completely normal examination. And also because the industrial event did not cause any objective, organic, or structural change to her arthritis, nothing to show that it really aggravated the underlying condition to make the industrial event responsible for the underlying condition. Those are the opinions that were accepted by Judge Powell in concluding that the discharge as of October 27, 2014, when Dr. Greenfield discharged her, was appropriate. Now, with respect to Mr. Wilmer's legal arguments, those are completely...
Before you go
Sure.
there, and I want you to go there, but the order in which you just described Dr. Bradway's testimony is sort of inverted, at least from my recollection of the record. And when a medical doctor in a case like this starts with structural change, that sort of, and the lack of it, gets our attention because that really isn't the standard for compensability. What's your response to appellant's argument that the only way to read this factual record is that the doctor focused on a legally incorrect, perhaps medically correct, but legally incorrect standard?
Well, I would respond, Your Honor, by saying it's not legally incorrect. Structural change is not relevant when you're determining compensability, but that's not our issue here. Mandex and all of the line of cases cited by the petitioner Absolutely, I agree 100%. They stand for the principle that if you have a symptomatic aggravation of a pre-existing condition, that in itself can be a compensable industrial injury. That's not our issue here. It was a compensable injury. It was accepted. Those line of cases also indicate that what the industrial carrier is responsible for is treatment for that aggravation, not the underlying condition itself. Now, getting to the issue of continuing benefits, Mr. Wilmer and I have litigated a number of these cases over the years. Some of these aggravations that are accepted are deemed temporary, like Greenfield and Bradway Field, this one is here. Some are considered permanent, and at times the carrier can be responsible for the underlying condition. When you're making that determination, not compensability, but determining whether that aggravation has ended, whether or not there is a structural or organic change is completely relevant. And if you look at the industrial indemnity case cited by petitioners, that's the sole issue that should be considered. I'm not saying that, but that's what this court in industrial indemnity said.
What if Dr. Bradway testified just to that and that it was dispositive? There was nothing else, so we need to ignore symptoms, would you be making the same argument there?
Yes, without an organic change. Fortunately, I have more to work with here, but under industrial indemnity, that's enough. Industrial indemnity, this court addressed this very issue of whether a symptomatic aggravation is compensable and to what extent in the context of a successive injury case, basically two carriers, an old injury, new injury, pointing fingers at each other, who's responsible. The new injury carrier in that case tried to argue that this is just a symptomatic aggravation, there was no organic change, so all the liability should stay with the old injury carrier. Court of Appeals disagreed, which is the correct reading of the law. No, they said a symptomatic aggravation is compensable, so liability is pushed to new injury carrier. But the court in industrial indemnity went further because the carrier's argument there was, without objective or structural change, we shouldn't be responsible. The court said no. Aggravation alone, symptomatic aggravation alone is enough to be compensable. However, if the new work activity also causes an objective or underlying change in the condition, the new injury carrier becomes responsible for the entire thing, not just the aggravation, but the underlying condition itself. The court also noted that the corollary is true. Without any objective underlying organic change, the new injury carrier does not become responsible for the underlying condition. They're only responsible for the aggravation. So clearly that is relevant, and that alone should have carried the day. But obviously Dr. Bradway's opinion was based on more than that. So industrial indemnity supports this perfectly, and unfortunately the petitioner's arguments about legally what's going on here are incorrect. An organic change is relevant when you're determining the extent of the injury. And with respect to credibility findings, the petitioner obviously was in dispute with some of the matters contained in Dr. Greenfield's report. And Mr. Wilmer did push Dr. Bradway on that on cross-examination. But a credibility determination is not relevant here for a number of reasons. One, this is a medical question. And Dr. Bradway did not feel that the petitioner's subjective complaints carried sufficient weight. He was aware that she claimed that she had symptoms all along, and in response to Mr. Wilmer's questioning, he indicated that that was not what he was basing his opinion on. He was instead looking at the objective data, mainly the fact that she had recovered per Dr. Greenfield's completely normal examination by October 27th without any ongoing problems. That combined with the fact of this is a very minor event. Mr. Wilmer described it as a twisting injury. I would submit in the records that that's not the way this is portrayed. The claim records and her testimony indicate that she was pushing a cart on wheels, and felt some pain while walking. There was no particular more mechanism than that. So this is a very minor event. In light of a history of a woman with severe degenerative changes in her knee that have flared up on and off over the years that required treatment, so much so that she was on anti-inflammatory medication at the time of the injury, long-term for that. So the fact that it was a very minor event, no different than the number of ones she'd complained of over the years that she recovered from, and that there was documented objective evidence that she'd received the appropriate treatment for this aggravation. It had worked. It had got her knee down to where it was completely normal on examination. That was more important to him than the petitioner's complaints that, well, I've had pain all along. Here, there was a true medical conflict. Dr. Miller was of the opinion this was a permanent aggravation and that the need for the knee replacement was related. Dr. Bradway did not, for the reasons that I've indicated. There's really nothing more to it than that. This minor injury was really just the onset of symptoms in the context of walking at work in light of her long-standing degenerative problems. It was accepted, it was compensable per the line of cases that the petitioner cited. It was treated appropriately. Objectively, it had resolved. What's going on with her now is just the progression of her degenerative changes, as noted by Dr. Bradway. His opinions are supported by reasonable evidence, and the ALJ was correct to rely on them. I'm not sure I had anything else to cover other than that, just to point out the industrial indemnity case and the specifics of Dr. Bradway's testimony. Are there any other questions?
Thank you.
Well, then I respectfully ask that the court affirm the award of the Industrial Commission, which the evidence clearly supports. Thank you.
Thank you. Just a few points. With respect to the efforts to bootstrap Dr. Greenfield's determinations into Dr. Bradway's opinions, I submit to you there's a factual conflict. That creates a foundational problem. Judge Powell didn't address that. And with respect to the facts before and after, I know we shouldn't be up here arguing facts, but if you read my brief, I've gone into detail as to what life was like before and after for Ms. Carter. The injury in question was not a minor injury. It was a pivoting. It's described, she said she was pivoting, pushing this heavy cart, felt a snap and a pop in her knee. With respect to industrial indemnity, that is distinguishable in the sense that, yes, it's a successive injury case. We're talking about which carrier is going to get stuck paying for treatment of a condition. And with respect to the suggestion that Mandex and Gulick and that line of cases only limits compensability to the initial injury, that's not correct. Those cases stand for the notion that compensability, the whole thing, traces back to did the incident bring about a change in the condition that requires treatment? And, saying, well, this is a minor injury, that doesn't make a difference. There's plenty of cases out there that talk about nominal injuries. One of them, which I didn't cite, is a case where the person was simply crouching down, and there goes the knee. If you're bending over to pick up a bubblegum wrapper at work and you hurt yourself, it's still a compensable injury. So I submit to the court that, yes, I'm well aware of the fact that the court wants to affirm the lower courts. That's your job, if you can do so by a reasonable theory of the evidence. And I submit to you that here that doesn't exist. It's clear that Dr. Bradway's viewpoint is in the mindset of a anatomic structural change.
No, I think what troubles me about this, having looked over Dr. Bradway's testimony, is it appears to me that he puts more store in information that is separate from what a patient explains. I feel this, it hurts bad, in the vernacular. And he puts more store in what he can see on x-rays or MRIs or other type of tests that are not going to be affected by a person's subjective explanation of how they feel and the pain they are experiencing. And doctors can do that. What is wrong with that? The fact that he puts more store into what is and I use the word objective, advisory, in an advisory manner, he puts more store into looking at things that are more quantifiable, for lack of a better term, than things that are more subjective.
Right, but when
I don't know of any case I've read in the world of industrial compensation law that says a doctor cannot do that.
Well, but his entire theory is based upon the notion there must be structural change. That's clear in his testimony. It's clear in his testimony. And when I tried to trap him on the question of, let's talk about symptoms alone, doctor. Let's talk about symptoms alone. Both doctors agree, yes, she has arthritis. Yes, she needs a knee replacement surgery. They both agree to that. When it comes down to the question of, is this industrial related or not, Dr. Miller says you need two things. You have to have x-ray findings that warrant the surgery, which she did. He also says you have to have a change in the patient's symptoms and an impact on their activities of daily living to where they say, look, I'm ready to have surgery. When I went down that road with Dr. Bradway, he would not answer that question. He wouldn't answer it. He left off by saying, I'm not going to go there with you. And I said, so just so we're clear, you're speaking from an objective point, and he said yes. He wouldn't answer the question about a subjective worsening. So, I submit to you on this record, the only reasonable theory of the evidence is that Dr. Bradway's thinking structural change. That's not the evidence, or that's not the law, and that for those reasons, this matter should be reversed and remanded. Unless there's any further questions, I'll leave 2 minutes on the clock.
Well, thank you all very much. We appreciate the time you spent with us this afternoon and your briefing in this special action. We'll take this matter under advisement and issue a decision in due course. Thank you.